received a few emails and calls about this Philadelphia DA staffer who was charged with child endangerment in Philadelphia for leaving her daughter in the car while she allegedly took her son on a walk in Philadelphia. I think the story said she was gone approximately 30 minutes or so, and when she returned, the police were there, and she was arrested sometime after that. It appears that the case will be prosecuted by the Attorney General's office in Pennsylvania, which frequently happens when there's a conflict with the local DA's office, as there obviously would be here, given the fact that she works for the office. I don't believe that she's an actual DA. I think she's within the administrative side of things on the DA's office. With that said, she's been charged with a felony offense, a felony of the third degree. This particular charge is kind of a hybrid criminal charge. It can be charged as either a misdemeanor or a felony, depending on the situation. I believe that she was charged with the felony given the child's age of 4. My reading of the statute indicates that there's 2 ways that a person can be charged with a felony in this situation. One, that the child was placed in substantial risk of death or serious bodily injury, and or the child's age. But the age alone will escalate the charge from a misdemeanor of the first degree to the next highest grade, which would be a ungraded felony. With that said, she's going to go through the preliminary hearing process in Philadelphia, where the judge will need to determine whether or not enough evidence exists for the case to proceed to trial. With regards to strategy, it seems that at this point they're looking at possible mitigation as opposed to defenses, but obviously that could change depending on what type of offer is potentially negotiated between her attorneys and the AG's office. If it goes through the preliminary hearing process, obviously, as I discussed in previous videos and podcasts, the evidentiary burden of proof is more probable than not that a crime occurred, and that standard is not very high. So based on my understanding of the story, and again, I haven't obviously looked at any discovery, there's a strong possibility that her case would be held for trial. Obviously, it doesn't mean she's going to be convicted, but I believe there's enough evidence there that a judge could probably hold the case for trial. But I've spoken before about preliminary hearings, and there's strategic reasons why an attorney will do a hearing or waive a hearing. And I've talked about that before in the past, about why an attorney does a hearing, maybe in situations where he or she knows the case won't be dismissed, but he or she is attempting to collect information to set up possible pretrial motions or possible defenses at trial. I don't know if that's not going to happen here. A final question that I've received is, could she face jail? Yes, she could face jail time, given that it's a felony grade offense. Her sentencing guidelines for a felony offense for this type of charge, I believe, are 3 to 12 months of county incarceration. A state sentence, obviously, the maximum punishment for a felony of the third degree or an ungraded felony in Pennsylvania is 7 years of incarceration. For a misdemeanor of the first degree, which this charge can be downgraded to either during a preliminary hearing or as part of a possible plea, either prior to trial or even at somewhere during or like right before trial. So all those are on the table. Again, I believe that her attorneys will go through that process with her and determine what the best result could be for her. I don't believe she would ever face the maximum punishment, obviously, but obviously jail, depending on the judge hearing the case and whether or not it was a jury trial or a judge trial. Again, all those would factor in. Obviously, it's my understanding she has no prior criminal history, so her sentencing guidelines would be low, but I wouldn't necessarily rule jail out or even house arrest of some sort, given the circumstances in the case. I don't believe the child was, it's my understanding the child wasn't in immediate danger, but obviously the circumstances, based on my understanding, the police could easily unlock the doors, and the child was at least old enough to manipulate the doors herself, I believe. So I think that was also in one of the stories that I read. I don't know if that's true or not. But again, these are all factors. I believe that probation, assuming that it's a plea, is more likely than jail, possibly some house arrest. But obviously, this person's an attorney, so that there's another side to this, whether or not this could affect her employment, her law license. I don't know. That isn't my practice area, but whenever we represent a professional person, a person with a professional license, like a doctor, a lawyer, a nurse, an accountant, we always have to have that discussion with that individual. And really, we want to investigate not only the criminal side, but also the civil side. So I would imagine that her attorneys will, again, go through that with her, and they will determine the best course of action. Obviously, the primary concern here is the possible criminal consequences, but also the secondary concern is what long-term effect it will have on her legal career and her ability to practice law from there. So with that said, if you have questions about any type of criminal charge, please give our office a call at 215-755-9000. You may also text us through the website. Like I said before, we've made various upgrades during the COVID outbreak to deal with the shutdown. I encourage you to visit the website. We have a lot of resources there for you and your family. Finally, our office is opening in second location in Morristown, New Jersey in June. Looking forward to that. I hope you all are doing well, and I will talk to you all soon. All the best.